name of streets. Where would you be if the post office changed the name of a street later and you tried to enforce a contract? And there is no 11th Street anymore. There's Happy Way. That's why we use a legal description. Much more specific, doesn't change. So you're going to have both in a real estate sales contract. And then the things we talked about before, we've been through this page already, and the following personal property. Not, actually, we haven't been through this page, and we went through the page with a similar concept in a residential contract. You know, what blinds and curtains and carpeting and fixtures and appliances and crud go with the property. Line, after you fill them in, line 9 says all this is collectively referred to as the property. That's the land we described. If you describe the land, you don't have to say with a single family house or with a 12-story office building once you've described the land. But you may want to say what chairs and typewriters and stuff. If there was an office, a furnished office, we talked about a motel, it might say with what beds and TVs. Those would be the personal property. As we talk about the contract now, they're all going to be together, the property, capital P. You want to get used to that term with a capital P, property, in line 9, because it's everything in here we're going to talk about is the property when you see capital P. You remember in a lease, we called it the premises. And that's pretty standard. Leases call it the premises. Real estate sale contract call it the property. Now, what's the purchase price? On line 10, you're going to fill it in. You're not likely to overlook this. We talked about in a written memorandum as required by the statute of frauds, you have to have the purchase price. Frankly, people spend more time on the purchase price than they do on anything else. So they're not going to overlook that. But here's where you put it. Here's where you put the purchase price. Then you talk about how it's going to be paid. Now, in A is the deposit. Normally, but not always, and not required, but normally the buyer is going to pay a deposit. It's called earnest money or good faith or down payment. It means a couple of different things. It shows my good faith. I'll put some money where my mouth is. I intend to buy. As a buyer, it shows my ability to perform. If I can't come up with a few $1,000s now, how in the hell am I going to come up with a couple of $100,000 at closing? But thirdly, we talked about, and you'll see later, we're probably going to get a liquidated damages provision later that's going to say that if the buyer refuses to close, this is the amount of money the seller gets to keep. So it's important. It's important to show the seller that the buyer means it, and to show that the buyer is willing to forfeit a certain sum of money if he doesn't close as my liquidated damages. Now, the deposit is consideration. And remember, we talked about every contract has to have consideration, but you don't have to have a deposit in order to be a valid contract. You remember we talked about consideration is promises. And right up there on lines 2 and 3, we had promises. Buyer agrees to buy, seller agrees to sell. That's consideration, that's a promise. The deposit is also consideration, but you don't have to have a deposit. Yes, Mary, sure. Question?
So I'm not clear on the liquidated damages, right?
Well, that's you're going to see at the back end of this contract, we're going to have a liquidated damages provision. I'm just preparing you now to think about. That's one of the purposes why the deposit is put up.
But it's not automatically considered for liquidated damages.
No, the contract would have to say that. Yeah, if you put up a deposit, that's just a portion of the purchase price due at the closing to show good faith. It gets forfeited as liquidated damages only if later you say that, and I was just preparing you now for that's coming later. But no, it's not liquidated damages until you say so later. Right now, it's just the buyer saying, I'm putting up some money here, to show my good faith that I promise I can close and that I show you I got a little bit of money. Understand here in the middle of line 11, the escrow agent. That deposit doesn't get paid to the seller. It's paid to some third party. And the reason is to have a third party holding the money until closing to protect the money. The seller may not own the property. You're going to find that out before closing. You don't want to give that seller money. It could be a life tenant. It could be a tenant himself. He may not own it. You're going to check out the title and find that out before the closing, but you don't want to give money to the seller. You don't want the seller to have any of that money until the closing. Because the buyer may be getting a refund. Something could go wrong that would make the buyer get his money back. You wouldn't want the seller to have it and have to sue to get it back. You pay it to some third party called an escrow agent. That's often a realtor. Sometimes there is no realtor. Sometimes it's a title company. Sometimes it's one of the lawyers for one of the parties. Buyer's lawyer, seller's lawyer holds it in his trust account. But if some independent third party who is not the seller is going to hold the pot of money until the closing. That's the escrow agent. So we then talk about who the escrow agent is and what his address is, etc. How do we get a hold of the escrow agent? Now, in lines 14 and 15, it's possible that we can have additional deposits payable before closing. Realtors love to see that happen, and it's good. After a month, maybe the buyer ought to put up a little more money. And maybe another month later, even more money. Additional deposits going into escrow with that escrow agent, but to be held until closing, to show further good faith by the buyer. I'm still in, I mean it, I'm still going to close, I promise. Here's another $10,000, here's another $20,000. After certain things are done, maybe after he gets his inspections, after a survey, after his title work, in other words, after each of these, as things are looking good going forward in the deal, maybe the buyer should put up some more money. If so, you put them there. In line 16, is there going to be any financing? Is the deal all cash? Is this all money coming out of the buyer's bank account? Or is there going to be a loan of some type? Usually there is. Real estate, most people have mortgages. This is where you talk about it on line 16. What's the amount of a mortgage? It's talked about here that the buyer is going to go get from a new lender. That's what they mean in this clause, where they say, see paragraph 5. In paragraph 5, we're going to talk about then the buyer goes out, files an application to a bank, asks for a loan approval, gets new financing. That's what we're talking about here on line 5. There are some other types of financing we'll talk about later, but this one refers to a new mortgage to be obtained between the date of contract and the date of closing, a new mortgage by the new lender that the buyer goes and gets. Okay. Other, who knows what other, what else you're going to, what other forms of payment, what other things could be done, what other types of financing might take place that are not a new mortgage, which is intended on line 16. And then at lines 18 through 20, you say, balance to close. This is the rest of the purchase price. In other words, obviously, if the purchase price was $100,000 and you had a $10,000 deposit, then the balance to close is going to be $90,000. How much money is left of the purchase price have we not talked about yet? But you might have filled in on line D, $80,000 was the new mortgage the buyer was going to get under $100,000 example. So if you did, balance to close would be $10,000. $10,000 deposit, $80,000 mortgage, $10,000 balance to close. And that money it talks about here with a cashier's check or a wire transfer. Frankly, you're going to find in every closing today now is a wire transfer. People don't even use cashier's checks anymore because they are getting counterfeited everywhere. People now with computers and printers print out bogus cashier's checks drawn on the Bank of Bogota and bring them in. They're total fake. They're no good. People want wire transfers now. That's federally wired money that gets wired to the closing agent and then wired to the seller. But it's a wire transfer of cleared federal funds. It's the only safe way to go anymore. Checks are written for the deposit early on because it can clear those checks. There's plenty of time. If the check bounces, you got no deal. But at closing, where we're gonna see the deed gets handed over, you don't want a bad check. Buyer gets a deed and is gone and records his deed and owns the property, and it turns out the check bounces. You can't have that. So you got wired money at the closing. Okay, now, next paragraph has some good concepts in it. Time for acceptance is the first one. And we talked about, okay, the buyer makes an offer and says, I offer to pay $100,000 for your house. The buyer says here when he wants an answer by. I want to know in 3 days, yay or nay or counteroffer. But the buyer here specifies how long his offer is in effect until it's revoked. Because we talked about, you remember, an offer can be effective until it's revoked. Well, we're going to put in here a revocation date. The offer expires and is revoked in 3 days or 10 days or whatever you want to put if the seller hasn't done something. Yes, ma'am?
Is that a form of contingency clause?
Say again?
Is that a form of contingency clause?
Not really. Not really. Because, and I'll say what to you. A contingency is something that takes place after you already have a contract. We don't have a contract yet here. Okay? This is the buyer saying how long my offer remains in effect until it can be accepted. After that, we can have some contingencies once there's been an acceptance and we have a contract, but it's not a contingency yet. So, this is merely how long the seller has to accept. It also talks about, you remember the seller might counter? If the seller counters, that's a new offer. And it says here the buyer has 3 days to accept a counter. When the seller counters back, that's a new offer. It provides here 3 days to be accepted. The point is, how long is an offer available for acceptance? You don't want it hanging out there forever, and you do put it, it makes sense, put a deadline on the seller. Tell him you got 5 days to think about it, ask your wife, ask your partners, whatever you want to do, but give me an answer in 5 days. Or else the offer expires. It talks about what the effective date is. The effective date is important, and that's the bold print. And what this is that when do we have a deal? When have we both agreed? We each have a meeting of the minds, we both understand we have an agreement on the property and the price and when we're going to close and all the other essential terms. That date is the effective date. That date is important because you're going to see a lot of time periods in the contract are measured from the effective date. They don't want to start the clock running on these time periods from the day the buyer first makes an offer. It may be a month until you have a deal, and you don't want that month to expire. You want your time periods to run from the date that we have actually a deal where the buyer and seller have agreed. So that's called the effective date because it measures time periods going forward, and it's important. And then it just talks about computation of time, and this is interesting. Strictly, when we have these time periods, how do we measure the time periods? Are they calendar days? Are they business days? What happens if these time periods end on a weekend? It's important to know of how we're going to count days here. This contract, of course, uses calendar days, but it says if you end on a weekend, you go to the next Monday. If you end on a holiday, you go to the next business day. The point is, how are we going to count these time periods? Because there are going to be a bunch of time periods. Where are we going to close and when? Isn't it section 4? What is the closing date? And as I mentioned to you, just like the price gets crossed out a lot, this one does too. Buyers and sellers have very different thoughts in their minds of when they want to close. When does the seller want to get out? When does the buyer want to get in? How long is it going to take to get financing? This gets crossed out and counteroffered and changed back and forth until the parties agree, often. That's where you put it. It also says on the next page where we're going to close. There's an interesting concept here that is a biggie here in Florida. In this last sentence on this page, it says, in the event insurance underwriting is suspended on the closing date and buyer can't get insurance, then you can postpone for up to 5 days while until the insurance underwriting suspension is lifted. What that's about is a hurricane is in the box. That happens here all the time. And what the contract is saying here is it's unfair to try to make the buyer close on a day that he can't get insurance. And the buyer has to spend his money and then has uninsured property. The buyer always wants to have his insurance in effect on the day of the closing. So from the moment he spent his money, he's protected. And if he can't get insurance, it's unfair to try to make the buyer close. If you haven't been through one of these, there's a certain box they draw on a map. And if a hurricane or a tropical storm is anywhere within the box, which is pretty big, nobody will write the buyer a new insurance policy. Which means his loan won't close because his lender won't close without insurance. And it's unfair to make the buyer close. So this talks about what happens if at the day you're closing, you can't get insurance. Let's delay the closing until you can get insurance. And top of the next page just talks about where the closing is going to be. And if you forget to fill it in, it says it's going to be in the county where the property is located, that's for sure. And that you may do it by mail or electronic means. You don't necessarily have to have a sit-down party for the closing where everybody meets. Normally you do, but you can do it by couriers, by FedEx and stuff like that. Now, Section 5 is this third-party financing that we talked about that was going to get filled in over on line 16. This is where we talked about if the buyer is going to go out after the date the contract is signed to get a new loan with an outside lender. That's what this is all about. And what the buyer is saying here, basically, we'll go through some of the specifics, but basically what this says is, if I, the buyer, can't get this loan, then the deal is off. So the buyer, you fill in all these blanks. That's how soon after the buyer has to apply for a loan, what interest rate the buyer is willing to pay, what kind of term and points, etc. All the terms of the loan the buyer is going to go look for. And as Marielle asked, I want you to look at line 53 in the middle. It talks about this financing contingency. This is a contingency. A contingency is a condition that must occur after the contract, but before closing, in order to have a deal. Under this paragraph, the deal is contingent upon the buyer's ability to get a loan. If the buyer can't get a loan, the buyer gets to cancel and gets his deposit back and the deal is off. If the buyer can get a loan and gets a loan commitment, then this financing contingency is satisfied and we're all going to move forward towards closing. And you know, we talked about this additional deposit thing here. Sometimes this is when an additional deposit comes due. The buyer might put up only $10,000 deposit initially because he's going to go apply for a loan. Once he gets his financing in place and gets a loan commitment, he might put up another $10,000 deposit or another $5,000 deposit or something more because it's looking more and more likely like you're going to have a closing. Okay. Now, in addition to the buyer maybe having to get financing, there are some other things that have to happen prior to closing. Section 6 is all about the buyer's ability to determine that the seller has good title to the property. Does his seller own it? If he doesn't own it, he's not going to have the ability to give me a deed at closing. So Section 6 talks about what kind of a deed the seller is going to give. Next week, we're gonna talk about the different kinds of deeds, but you fill in here what kind of deed the seller will give. There are a couple different kinds. What's title gonna be subject to? And then a real important clause at line 70. Lines 64 through 70 says title's going to be subject to whatever restrictions are of record and zoning and other encumbrances and other rules and regulations of what you can do with the property. Buyer says here at line 70, however, there may be no restrictions that will prohibit my use of the property as a nimine. The buyer fills in here his intended use of the property. If he intends for the use, let's say there's a warehouse on the property, and he intends to have a manufacturing facility to make chlorine, then buyer fills in here, there may be nothing that prevents my intended use of the property as a factory, as a chemical factory to manufacture chlorine, because that's what I intend to use the property for. And if there are any restrictions or zoning or other title encumbrances that would prohibit me from it, I don't want to buy it. This is not really a contingency because it's not an event that's going to happen. This is more of a condition. There may be nothing there that keeps me from using the property for what I intend to use it for. Now, between now and the closing, the buyer is going to check that out. The buyer is going to check zoning, and he's going to examine title restrictions, and he's going to check to make sure the property can be used for what he intends to use it for, and he's not going to close if it can't be used for that. But the point is here, the buyer may not be forced to close if there's anything of record anywhere that will prohibit his intended use. And remember, this could be buying vacant land and he intends to build a 4-story building. So he may say here, provided there's nothing that prevents me from building a 4-story apartment building. And he might then find out there's a height restriction of 30 feet, that he can't build a 4-story building. So the buyer puts in here, here's what he's going to use the property for. I'm going to take a break too. Let's take a 2-minute break, and then we'll continue. Okay, let's go back to section 6, bottom of page 2. What this is all about is that sometime between the signing of the contract and before the closing, the buyer has to make sure that the seller has good title, that the seller really owns the property, really has the right to sell it. Section A is evidence of title. The seller is going to have to provide to the buyer, and you fill in all the blanks here, where, when, how, at what expense, evidence of his title. The seller, there are two different ways to do this. We'll talk about some of these later. You check either the first box or the second box, I guess little I and little 2I, either with a title commitment or an abstract of title. But the point is, this is the seller has to prove to the buyer that the seller has good title to the property, can convey good title at closing, what his liens are, what claims are out there against the title of the property. Subsection B, at the bottom of the page, then the buyer has 15 days after he receives the seller's evidence of title to examine it. And if the buyer finds anything wrong with the seller's title, within that 15 days, the seller has to specify the title defects to the seller. And then it goes on to say if there are some defects, the seller has a period of time to clear up the defects, to clean up the title in order to perfect his title so that we can go forward with a closing. Now, related, the buyer is also going to want to get a survey of the property. And we're going to talk about surveys in another chapter called legal descriptions. A survey is a drawing of the property and of all of the land and all the improvements on the land. The buyer's going to want to get a survey in order to determine what he's buying. And this is all about getting a survey and the buyer's survey rights and the seller giving him a copy of the seller's old survey, and then the buyer gets a new one when he gets it, what happens if there are problems, etc. D is interesting, and this is something we have talked about already. Seller warrants the property has ingress and egress. That's access we talked about before. You remember that a piece of property must have access to public roads. If it doesn't, it's landlocked. You can't get to it. You can't use it. So it's either fronting on a public road or it has easements, but it has ingress and egress, access to public roads, and the seller warrants that. Because you're going to see, interestingly, we're going to talk about this in a minute, next. This is very much an as-is contract, where this is the seller saying, I'm not guaranteeing much of anything, but I am telling you I have good title, and I am telling you that the property has access. So even when the seller says, I'm not guaranteeing anything, this contract form requires the seller to warrant at a minimum that he has good title, and he has to give evidence of it, and that the property has access. And the reason access appears here with the survey is because that's how you see what the access is. When you look at the survey, you see, is this property fronting on a public road? If it's not, is there a drawing of an easement or a private road or a path or something that allows me to get to it? You're going to see all that on a survey. Okay, now, condition of the property. That means what shape are the improvements in? You know, dilapidated or in good repair? The seller says in the first line here, because this is a commercial contract, that the property is being sold in its as-is condition, ordinary wear and tear accepted. And that's it. And it goes on, meaning no guarantees on the condition of the property, as is. Line 111, seller makes no warranties other than his good title. And that's what we talked about in the prior paragraph, his good title with access. And the buyer agrees. that he's accepting the title, the condition of the premises as is, without any guarantee from the seller against any defects. And there are two ways for the buyer to say, I'm taking it as is. The first one, in little a here, that virtually never happens. That's the buyer saying, I've already inspected the property, and I don't even want to inspect it. I'll accept it as is. Now, there is one way that happens. If the buyer is already in possession of the property and already knows all about the property. You might be a seller selling here to his tenant, who's been in occupancy for 3 years. Probably knows more about the condition of the property than the seller does. So he wouldn't want to do any inspections. He may already know. Other than that, most buyers wouldn't be willing to say, and I'm not even going to check it out. I'm happy. That's what he does in A. What usually happens is in B here. In virtually every commercial deal, and it's getting to be the case now in most residential deals, and it's the right way to go and the smart way to go. And it's called a due diligence period. You'll also hear this described as an inspection period. And what this is all about is the buyer has a certain period of time to check out all the improvements on the property and make sure the buyer is happy. Get a termite inspection, get a roof inspection, get an engineer in there to make sure the building is sound. And check zoning, check parking, check out everything about the property. Check out environmentally. Was there any chance that there's been a fuel spill here on the property? Check out every single thing imaginable about the property and the condition of the improvements and the use to which the property can be put, if you're going to change the use or build something that's not already there. During this period, the buyer has the right to make whatever inspections he wants with whatever professionals he wants, and make sure that, as you'll see in line 118, to determine whether the property is suitable in buyer's sole and absolute discretion for buyer's intended use and development of the property. In the buyer's sole discretion. Buyer, are you happy with everything that relates to this piece of property? And at the end of that due diligence period or inspection period, the buyer says yay or nay. And if the buyer doesn't say nay, he is saying yay. The point is, at the end of that inspection period, the buyer is supposed to write a letter to the seller and say either the property is acceptable, I'm go, or the property is unacceptable, I cancel. And the buyer gets his deposit back. If the buyer fails to write either one, he's deemed to be saying go. If he fails to write a letter that says, I cancel, give me my deposit back, he is deemed to be saying, I'm going forward, let's close. And the point of this paragraph is simply to say, buyer, you've had this period of time to check everything out and get happy with everything. Don't rely on the seller for anything as to the condition of the property or the usability of the property. This is intended to close out the seller's liability and for the buyer to assume all responsibility, saying, I'm happy. Yes, Laura, go ahead with your question.
Oh, I found it. Yeah, I was going to ask.
Okay,
if it has to be
so
paid.
and you either saying, I accept, let's go, let's close, or I terminate, give me my deposit back. And again, this might be another situation where the buyer might put up an additional deposit under those additional deposit clauses in the contract. This is normally when it happens. The buyer's checked everything out and is happy. Okay, go ahead and put up some more money. Prior to that, there was no reason to put up any money because he could cancel and get his deposit back anyway. So this is another type of condition where you might have an additional deposit. It just says at the end, there's gonna be a walkthrough inspection on the day of the closing, for the buyer, make sure everything's still okay. That's fine. Make sure the building didn't burn down. Make sure everything's still there. Make sure everything's still the way it was at the end of the inspection period. Okay, now, paragraph 8. During this contract period, which may be 60 days, and let's relate to real world how some of these things happen. Very often, the inspection period is 30 or 45 days. And the closing is maybe another 15 or 30 days later. So you may have a contract period from the date of contract until the closing of 2 to 3 months. During that 2 to 3 months, how is the seller going to operate the property? What kind of condition is he going to keep it in? Can he enter into new leases or not? Can he make changes? That's all regulated here by Section 8. Section 9 talks about, okay, when we get to closing, what are we going to do? What's going to happen at the closing? The buyer realized at this point, has done all his inspections and has said, go, I'm closing. If he had to get financing, he's already arranged his financing because he didn't cancel because he must have gotten his financing. So now we get up to that closing date, we're going to have a closing. What's going to happen now at closing? Possession and occupancy. Well, at closing, the seller is going to turn over possession to the buyer. Going to give him keys, Security Act codes, possession, of course, means normally if the seller gets out and it's an empty building, but in a lot of these cases, this is leased commercial property and the tenants are in possession anyway. So the seller doesn't really get out of possession, he wasn't in possession. The buyer doesn't go into possession because the tenants are there. But he turns over the right of possession to the buyer at closing. Costs, there are going to be a bunch of recording costs. Who's going to pay them? That's all in paragraph B here on line 155. Recording fees, notes and mortgages get recorded. They have fees due to the state of Florida. This talks about the buyer paying them. There's a big stamp tax on the deed that the seller pays based on the purchase price. This talks about who's going to pay those. Section C, beginning on line 159 and going for about 12 lines here, talks about all the documents that are going to get passed around at closing. Deed, bill of sale, affidavits, assignments of leases. They're at closing, conceptually, of course, there's going to be a transfer of the property and of money, and there's going to be a lot of documents signed up. This talks about all the documents. Lines 173 through 178 are about prorations. There are matters, financial matters between buyer and seller that have to get settled at closing. And they are as to things that are ongoing. Whatever day you close, there are going to be certain matters that have to be adjusted between buyer and seller. And the minimum utilities, of course, you would think of. But if you close on the 15th of a month and all the tenants paid their rent on the 1st of a month, well, we're going to have to adjust those rents. The seller collected all the rents on the 1st of a month. We're closing on the 15th. The buyer was entitled to the rent for the second 15 days of the month. We're going to adjust that on the closing statement. We're going to adjust real estate taxes. That's a biggie. Real estate taxes cover the whole calendar year, but they only get paid at the end of the year. You close any time during the year, we're going to have to adjust those real estate taxes because only one person is going to pay them at the back end of the year. But if you close in the middle of the year, you got to adjust those. These are called prorations. Those are matters of income and expense of the property that have to be adjusted between buyer and seller. And they get adjusted at the closing. Paragraph here on special assessment liens. This doesn't happen very often. This is like, what if the county or the city has levied a lien on the property for, let's say, connecting to sewers, or for sidewalks, or for street widening, or, you know, governmental improvements where they lien the property. This talks about who's going to pay them, and it's based on how far along are they. Section F is important. There's an interesting history to this that I'm going to skip, but foreign investors have to pay, when they sell, capital gains taxes, just like everybody else. When you sell property and have a gain, you have to pay gains taxes. In the old days, foreign individuals didn't have to pay capital gains tax to the United States. In the 60s and 70s, our government said, come on foreigners, come invest up here. When you invest in property and make money, we won't tax you on it. Well, they changed their mind. And they said, sellers will have to pay gains taxes, and the Internal Revenue Service is concerned about foreigners skipping and not paying their taxes. So if the seller is a foreign individual, 10% of the purchase price has to get paid into escrow at the closing and paid over to IRS.
10%?
10%.
It's standard.
The concept of that is to cover an estimate of what a gains tax might be. Then it's up to the seller, the foreign seller, to apply to IRS and say, hey, I sold at a loss, give me my money back. There is no gains tax. And if the seller can prove he sold at a loss, he'll get it back. But the point here is, IRS was getting stiffed by foreign sellers when a guy in Venezuela would sell a piece of property and the money would go back to Venezuela. That guy wasn't filing a U.S. tax return. And he made a gain and he wasn't paying his gains taxes. So this is how IRS enforces with foreign sellers, getting a shot at getting some tax out of foreign sellers to pay for their capital gains. Now, the parties have to execute documents at closing saying the seller is not a foreigner. And if they can't execute those documents, then that money's going to get paid in. So this is telling the foreign seller right here, 10% of your purchase price is going to get paid into escrow at closing. You go deal with IRS later to try to get it back. That's the deal in every real estate closing, whether it's commercial or residential, it makes no difference. If the seller is a foreigner, 10% of the money goes to IRS, unless you can find an exemption. Escrow agent, we talked about the escrow agent as the third party that's going to be holding the money up until closing. This is about the escrow agent's rights and what he does with the money, what he's allowed to do and not allowed to do. What happens if he gets sued? When the buyer and seller get in a fight over the money, they both sue the escrow agent and say, give me the money. This is all about his rights and what he's supposed to do if he gets sued. Section 13 is important. Default. This is breach of contract. We talked about a breach. Default equals breach. This is what if one or the other of the two parties prior to closing breaches. 13A is, this is if the seller breaches. In the event the sale is not closed due to any default or failure on the part of the seller, then here's what happens. The buyer, one, may elect to receive a refund. Call it off. All right, forget the whole thing, give me my deposit back. Or, number two, this is what I talked to you about being the most important remedy there is, seek specific performance. The buyer can say, Your Honor, make him sell it to me. Make him give me a deed at closing. Remember we said the seller defaulted. Seller might just decide, I don't want to sell anymore. I don't care what the hell the contract said. I'm not selling. Change my mind. This is, Your Honor, make him specifically perform his obligations under the contract and give me a deed. Okay. B, what if the buyer doesn't close? Default on the part of the buyer. Seller may, one, Mariella, here's what you asked about before. Seller may retain all the deposits paid or agreed to be paid as liquidated damages. And it says that right here, liquidated damages, as consideration for the execution of the contract and the full settlement of all claims, upon which case this contract will terminate. This says that the deposit shall serve as liquidated damages in the event the buyer doesn't close, or the seller can seek specific performance. He can say, Your Honor, make him close, make him buy it, make him pay the money. Okay. These are where our remedies come into play we talked about for default. Now, there were other remedies. We talked about damages, or we talked about rescission. This contract doesn't allow those remedies. This contract, the parties agree what their remedies are going to be, and they're limited to getting the deposit back or getting the deposit and specific performance, or in both cases. Paragraph 14, we talked about the prevailing party attorney's fees. That's what this clause is. Line 230, you see prevailing party. In the event of any claim or controversy arising out of this contract, if the parties get in a fight, if the parties have a dispute, the prevailing party, the one who wins, will be awarded his attorney's fees and costs. That means the prevailing party gets his attorney's fees paid by the losing party. Notices is all about how you give notice to the other side. You know, what methods you may use for notice. It is what it is. You can read them. It's not important to know right at this point. Disclosures. There are a whole bunch of laws out there that say that every real estate contract has to disclose a bunch of things. Well, here they are. None of them is really significant, but they're in here because the law requires them to be in here. Risk of loss is what we talked about in section 17 on line 252. This is what if something happens to the property between now and closing. The risk of loss of the improvements. What if there's a hurricane? What if there's a fire? What if there's other casualty? An earthquake? A sinkhole? What happens if the improvements or the property are damaged between now and closing? This basically says the seller bears the risk of loss up until the closing. The buyer can cancel and the deal's off. It's the seller's risk, meaning, seller, it's your obligation to protect the property and keep it insured up until the closing. Assignability, section 18. Remember we talked about a contract can be assigned? Well, this is where you say either the contract is assignable or is not assignable, and you check the appropriate box. Most parties are going to say not assignable. Miscellaneous is a few other small terms. Handwritten control over typewritten, a few of the things we talked about. Any changes have to be in writing, standard junk. Paragraph 20 is about brokers. We're going to talk about brokers at length in a few minutes. But this is where you name the brokers. You say, who are the brokers? How much are they going to get paid? What roles are they serving? Whose broker is whose? What's their commission going to be? You fill in all this stuff in paragraph 20 where you list, often there are two brokers. We'll talk about those. The one who had the listing and the one who actually sold the property. Who gets paid, how much, what their commission is. Now, section 21 talks about there may be an addendum to this contract. You could put in this contract, if you wanted to, the 11 things you see listed here are other types of paragraphs that conceivably might relate to this deal, but they might not. Rather than having the contract be another 4 or 5 pages and listing all these clauses that may or may not apply, what this contract says is there may be attached as an addendum a special paragraph about the following types of things. And we're going to talk about those in a minute. If there is such an addendum attached, you put a check mark here where you're saying an additional part of the deal is clause on the following subject. Paragraph 22 is where you type in additional stuff, additional special paragraphs, an additional contingency. This might very often contain contingencies. Seller says, I'm not bound by this contract unless my new job comes through, because I'm not leaving. If I don't get the job I think I'm getting, I get to cancel. I'm not selling, deals off. Line 321 is important. It says, we, both parties, intend for this to be a legal binding contract. And then the brokers go on and say here, and if you don't understand it, go get a lawyer before you sign it. Okay. You sign it on the next page. I told you that there were 3 most important things about the contract. Here's number 3. Get the right signatures. Get binding signatures. Here's where people sign it and date it and type or print their name and put their title if they're signing in a capacity. Binding signatures we talked about. Remember we talked about before, and I think Laura, you asked about, can you check on SunBiz? This is where you make sure you got the right people. If your seller is a corporation, you make sure you got the president here. If it's a partnership, make sure you got a partner. If it's a limited partnership, make sure you got the general partner. This is where you get the binding signature, because if you don't get the right signature, you can't enforce the contract. If you don't get the real owner as a seller, it's no good. If there are 3 real owners and you get 2 of them, it's no good. You got to get them all. We're going to talk about where you find that information next week. But the point is, get it right. And the 3 things we talked about as being the most important parts of the contract, the first 2 were right at the beginning. Name the parties correctly. Describe the property correctly. And over here at the end, get them signed up correctly. Get them all and get the right ones. Okay, now, we talked about an addendum. I'm going to go through these quickly because you might decide that there are certain additional concepts that you want to include in your deal. What this is the FAR, the same Florida Association of Realtors, has put together a 3-page list here of paragraphs that you might want in your deal. If you do, you initial them and check them and fill them in, and then they're part of your deal. This is an addendum. Anything added to a contract is called an addendum. So you see, it begins here on line 1 with addendum number 1. This would be the first addendum to your contract between the parties, etc. The first one is arbitration. Remember we talked about ADR, alternative dispute resolution, and arbitration. The parties might specify here that rather than to go into court if we get in a fight, we're going to have arbitration. So if both parties initial this clause, it's part of the deal, and there's going to be arbitration rather than litigation if you get in a fight. In section B, 1031 exchange. I don't know if you recall last time, way out in the left field, the book just started talking about a 1031 exchange, and we said wherever it came up, it wasn't relevant at all. It's a tax issue. It might be that one of the parties wants to have special tax treatment where he defers his gains tax here. If so, you initial these clauses. Section 1031 applies. I could take about 10 minutes and explain to you what it is. I don't think it's worth your 10 minutes. But it's all about if the seller is going to have a gains tax, a taxable gain, and he doesn't want to pay it at the time of this closing, and he wants to defer it till later. You follow this procedure under Section 1031 of the Internal Revenue Code, so the seller can put off paying his gains tax. Now, you remember our contract form talked about the due diligence period and said that the seller didn't guarantee anything, that it was up to the buyer to check it out and make sure he was happy with everything and cancel or not cancel, but there were no guarantees. You can change that concept if you want here. And it says, as it begins, paragraph 7 of the contract is deleted. That would delete that entire paragraph that we talked about that said as is. And you would instead have this section. And what this section is where the seller does guarantee a lot of stuff. The seller guarantees the condition of the improvements. Still, under section 1, the buyer is going to get a bunch of inspections. But what this says is if the buyer finds any problems, on line 39, the seller will pay up to blank % of the purchase price to repair the problems. It might say 2 or 3%. So here the buyer would get a roof inspection or a plumbing inspection. And if he found problems, in our $100,000 example, if it said 3% here, the seller would pay up to $3,000 to repair those batteries. Same thing, the buyer will check to see whether there are any environmental problems, and seller will pay up to a certain limit to clean it up. In subsection 3, whether or not they're termites. Buyer gets a termite inspection, seller agrees to pay up to a certain amount to repair termite damage and to treat the property. So under these sections, the seller is guaranteeing the property's improvements are in good condition and is agreeing to pay to fix them if they're not, as opposed to the standard where the seller says it's as is, I'm not paying nothing, buy it or don't buy it. Inspect it and then buy it or don't buy it. Here, inspect it and I'll stand behind it with my checkbook, I'll pay to fix it. Okay. In section D, the seller might guarantee certain things about the property, this being commercial property, including most particularly in section set on line 73, the seller might say last year the property generated dollars in income and had dollars of expenses. Commercial property, buyers are looking for a return on their money. What is the income to be generated from the property? And what are my expenses going to be? What are my taxes and insurance and stuff like this? Here, a seller might guarantee the operating income and expenses of the property. If that's the case, sellers might not be willing to do it, in which case the seller won't agree to this. But if both parties agree and you fill in the blanks, then seller's making those guarantees. Seller might make additional warranties about the property, about there's no bankruptcy and how many tenants there are and assessments and zoning, etc. That would all be in section E if the seller is going to make those guarantees. Might not, might agree. Section F is the coastal construction control line. This is pretty rare that this applies. We've got a law that says that on oceanfront property, oceanfront, where there are tides, the line to which the buyer can build, which is up to the high tide line, is called the coastal construction control line. The seller, nobody could ever build seaward of the high water line. This is all about making sure the buyer understands that he can't build outside the high tide line. It's pretty rare. Flood hazard zone. Most of our property in South Florida is in a flood zone and is going to require flood insurance, and this is where you talk about it. Is it or is it not in a flood zone? Is flood insurance required or is it not? If so, what's the average of, what's the guaranteed maximum amount that the flood insurance is going to cost? That's all in section G. Now, financing. We talked about the financing section of the contract, talked about the buyer going out and getting a new loan, a new third-party loan. The buyer goes to a bank and applies for a new loan. But there are other ways a deal could be financed. In section H here, the seller might accept a mortgage back. The seller might take paper. The buyer might pay $20,000 down in cash and execute an $80,000 mortgage back to the seller. That's what this section is about. If so, is the seller willing to do the financing? What will the rate be? What will the payments be? What's the term? Talk all about the terms of the financing if the seller is going to finance the deal. Or, under line I, existing mortgage, there might be some mortgages already on the property that the buyer could assume. In the old days, this is how all deals were done. 60s, 70s, buyer always took over the seller's mortgage and just, you know, like this is take over the payments. You read about that in cars and stuff like that. Take over the payments. This is take over the payments on an existing mortgage. In the old days, deals were always done this way. Starting at about the 80s, all loans said, no, they may not be taken over. It's coming around again. Now loans are sometimes assumable, transferable. So if the buyer is going to take over the seller's loan, that's what this paragraph talks about. How big is it? What are the payments per month? What if he's going to take over 2 mortgages? Well, that's the second part here. That's really pretty obtuse. That's pretty rare. But if the seller has 2 mortgages on there and they're both assumable and the buyer is going to take over both of them, well, then these are the terms of those mortgages. Lastly, the last 2 are clauses where you can sign the contract now and your attorney has 5 days to review it and say whether or not the attorney approves or disapproves. So buyer would put in this clause here where he says, I agree, but my buyer's attorney has 5 days to review the contract and cancel it if my attorney says I did bad. Similarly, a seller may say the same thing. Seller may say, okay, I'll accept your contract now, but I want 5 days for my attorney to take a look at it. So this is a way that rather than reviewing the contract before it's signed, the parties can go ahead and agree on essential terms and the lawyer will look at it later. Now, that's it for this form. What I'd like us to do is to go ahead and take our lunch break now. Let's start back at 1 o'clock. And what we'll do then is go back through the rest of Chapter 11, where the materials talked about the different types of clauses that might be in a real estate contract. And we'll have seen most of these already and be familiar with them. They'll talk about some other types of clauses that we haven't seen yet, and we'll discuss those at greater length. But most of them we'll have already discussed, and at least you'll be able to recognize them and picture them and say, yeah, that's what this looks like, I just saw one. So at 1 o'clock we'll do the second half of Chapter 11. I'll see you then. Thanks.
It's cold, I'm gonna go get my jacket.
I'm gonna get some tea to warm up too. Just to get my wallet.
Hello. But what, I'm sorry, you didn't hear it. Wow, what, are you still in Toonies? So how do you like it? Well, I'm glad. More like Whole Foods or more like that little Trader Joe's I went to in San Diego? Okay. Well, that's great. I bet Maggie will too then. I'm sure Maggie will too, and it's a lot closer than Whole Foods, which is a bitch of a drive. When I mentioned it to Fred, he said that he thought that was notoriously bad parking in that shopping center. That notoriously not enough, particularly in the hours when the gym is busy. They fill almost the whole thing during the gym hours. So it's not going to be a good place to go in the evening when everybody's going to the gym after work, you know. Good for you. Okay, honey, well that's great. Well, I see you all having a good time. I think so. I actually feel good about it. Yeah, we're going to start back in 5 minutes, and I think we may finish a little early, but I feel like it's going well. We started a little late, and we may finish a little early, but so be it. But I think the discussion's going well, and you know, good subjects. I'm pleased with what we've been doing. Well, okay. Well, I appreciate you calling. Do you guys have more plans? Well, did you eat lunch as a part of this? Okay, but no other plan other than that. Uh-huh. Oh, okay, great. Okay, cool. So oh, that's great, honey. Well, that's good. I'm really glad you're having a good time. I'll do it. No kidding, really. All right, sounds lovely to me. That's really nice of Con. That's very nice. Okay, honey, thanks. I'll talk to you at 3-ish. Love you, bye.